Hello everyone. I'm going to deliver a lecture now about parliamentary sovereignty. This is relating to the law of England and Wales, but it relates to the law of the United Kingdom more broadly. So, Parliament is supreme in the UK Constitution. It can make or unmake anything. It can change who the monarch is. You can look back to, well, before the United Kingdom existed as such, 1688, or really the Act was passed in 1689 and so on. So Dicey, whom I've mentioned in previous lectures, had 3 rules about this. I'll come on to this a little bit later. But this notion of parliamentary sovereignty is possibly limited by European Union law. Now, the United Kingdom just left the EU a few months ago, but some of these laws are still binding, so it seems. What about being signed up to the European Convention on Human Rights and the Human Rights Act of 1998, which incorporated that into domestic law, which took effect in the year 2000? What if Parliament were to pass an act in contravention of the European Convention on Human Rights? Would such a law be valid or not? It's debatable, because the Supreme Court simply doesn't strike down any acts of Parliament and has no legal power to do so, although some might dispute that. So, sovereignty. Well, there's legal sovereignty, as in where the law is applicable, where the writ runs. There's political sovereignty. It's the right to fashion law and so on, to repeal laws, and these overlap very considerably. But when law gets to the more theoretical end of the spectrum, it's rather unclear what the law is, and we're in the realms of conjecture. Anyway, there was that Revolution 1688, which some call glorious. There was a new constitutional settlement. But one of the few things that everyone can agree on about 1688 is it established parliamentary supremacy. And this has simply been enhanced by democracy in the modern era. Obviously, back in the 17th century is very much plutocracy. So the United Kingdom doesn't possess a codified constitution, or some say it's entrenched but not codified. It's difficult to say what it is. But parliamentary sovereignty is certainly a core principle of the UK Constitution, such as it is. And can that be separated from political sovereignty? Possibly not. It's very questionable. So Dicey, the Vinerian professor of public law in the University of Oxford in the late 19th, early 20th century, he said there were 3 key rules about this. Parliament is the supreme legislative body. Don't think anyone would dispute that in the UK. No parliament can bind its successor or be bound by a predecessor, and Bagehot made the same point. So Dicey also said that no person or no organisation can dispute the applicability of a parliamentary act. So that's that. Well, sure, they can dispute it, but it can't be defeated by a judicial ruling. So Dicey said that Parliament has the right to make or unmake any law whatsoever. But who is Dicey? He's a professor. His opinion is contentious. It could be wrong. Moreover, he said that over 100 years ago. That's not actually a constitutional law in itself. All right. So it could be said that there's no restriction on the acts they can make. Now, Sir Leslie Stevenson, we have to say, well, come on, we have to look at the subject matter of the acts. If Parliament passed a law to say that the world is purple, it wouldn't actually make it purple. We can't be plain silly about these things. Now, in Mortenson and Peters, a 1906 case, it was decided that there was a certain geographical limitation to the acts that Parliament could pass. It couldn't pass acts pertaining to zones over which it has no control. And there's some sort of time limitation. The Law Damages Act in 1965 being a case in point, or the War Crimes Act 1991 about things that happened in the Second World War. Anyway, so legislation can't be made such that it can never be repealed. And we sometimes repeal things by implication. Or as the famous saying goes, a sovereign power cannot restrict its own powers by any particular enactment. Right. So go on to what implied repeal is. A subsequent act of Parliament sometimes impliedly unmakes a previous act which conflicts with it, and obviously the more recent takes precedence over the more antecedent. For instance, Vauxhall Estates, or another case, Ellen Street Estates. This is what's known as continuing sovereignty. So it replaces the previous ones. Now, there are certain restrictions on parliamentary sovereignty. Can Parliament actually restrict its own powers? Substantively, possibly, procedurally, in how it actually operates, or perhaps by manner and form entrenching certain ways of behaving. Anyway, so some people say that Parliament can, in fact, limit itself through procedure. Or, for example, you could look at the Attorney General for New South Wales and Trethowan, a 1932 case. But some people say, no, that's only about Australia. It doesn't apply to the United Kingdom. There's also a way of entrenching things procedurally. There will be certain instances of this. How about Jackson and Attorney General, or the EU Act from 2011? The Parliament Act of 1911, because its procedure allowed some exceptions. For instance, it restricted the actions of the House of Lords, and obviously there's a Parliament Act of 1949 updated that, reduced the Lords' power to even just a one-year veto. So therefore, we have things which limit the powers of the House of Commons or of Parliament, both houses, possibly. How about a referendum lock, saying, well, Parliament can't do such a thing without a referendum, pursuant to the European Union Act of 2011. Okay, so no one can legally challenge the legality of an act of Parliament. So no person is thought to have the right to override any legislation coming out of Parliament. So prior to 1688, some people say, well, the monarch could just flat out refuse to sign, and that would be it. There was monarchical veto. Anyway, so there are ways to challenge things even after 1688. Say, well, perhaps Parliament hasn't enacted the legislation properly. Okay, that might be a way in which parliamentary sovereignty could be limited. Or there's a case, Edinburgh and Dalkeith Railway against Wauchope in 1842. Or Picken and British Railways Board in 1974, when challenges were launched on procedural grounds. All right, there's the Enrolled Bill rule, and this is what Lord Morris had to say in Picken and the British Railways Board. The court's function is to administer Parliament's laws. There may be arguments over interpretation, but there is none as to whether it should be on the statute book, because that's a close quotation, because that's a political question. It's not for the judges to say whether it should or should not. If you have a view on that you really want to enact, then you have to enter the political arena. So perhaps there's substantive limitation owing to European Union law. Remember, on New Year's Day 1973, the United Kingdom acceded to the European Union. The Treaty of Rome had been signed. Sir Edward Heath, well, as he was later, the Prime Minister, he went to Brussels to sign it, and later the Act of Accession was passed, and the European Communities Act was passed in 1972. So the United Kingdom is a dualist country, not a monist country. That's to say, if the UK ratifies the treaty, that doesn't automatically make it part of domestic law. It has to be specifically transposed into domestic law. So as part of the European Union, the UK seemed to be part of a new legal order. There was Van Gent en Los, that celebrated a case from 1963. So it was held that the European Economic Community creates a new legal order. The European Economic Community, EEC, has since morphed into the European Union. It's a new type of international law, and it's binding upon the member states. They have voluntarily limited their sovereignty or pooled their sovereignty in certain areas. Okay, so one thing is crystal clear, or for European Union countries, the European Community law, or EU law we might call it now, and that trumps the law of member states. So EEC laws has a limitation of sovereignty rights on the member states of the EU. and so a subsequent unilateral act which is against European Union law shall not prevail if there's any collision. And that was decided in Costa and Enel, a 1963 case. Anyway, so as I said, European Union law was transposed into United Kingdom domestic law, so perhaps that impliedly repeals some parliamentary acts. The European Communities Act in 1972 said the community law shall be given legal effect in the UK. And Sir Edward Heath, he said to the people that there would be no loss of essential national sovereignty. Well, what's that? Now, you might say there's no loss. Let's not use such a loaded term. Let's call it pooling of sovereignty or something of that nature. But perhaps he was right. But I think he was pinning his hopes on the operative word essential. How much is essential? Some bits might be inessential. The European Communities Act 1972, in Section 2, Part 4, it says that EU law must be given a certain construction, that any act passed or to be passed shall be in line with EC law, right? So it's prospective, not just retrospective, obviously. All right. So the UK has gradually accommodated itself to the new situation. Lord Denning said that European law was an incoming tide. It was going to have an enormous effect on UK law. That might be splendid, it might be woeful, it might be morally neutral, but there's no doubt that it has had a tremendous effect. So there's a case which was pertinent here, that's Bulmer and Bollinger in 1974, or Felixstowe Docks in 1976, McCarthy's Limited and Smith in 1979. So one could take an interpretive approach, like Garland and Brell in 1983, and Lord Diplock was sitting on that case. So what was his ruling from the bench? He said, the words of the statute are to be construed if they are reasonably capable of bearing such a meaning as intended to carry out the obligation. End of quotation. So that if possible, you have to understand UK law as being in consonance with European law, right? If there's some doubt, you've got to lean towards doing what EU law would have you do. Or Pixton and Freeman, a 1989 case, said there's purposive construction. Construction in this case doesn't mean building things, it means like the exegesis of the legislation. Like to construe things. You might have heard of that if you've learned Latin a bit. Right, so there's Litster and Fourth Dry Dock, a case from 1990, in which the judge ruled it is a duty of the court to give a construction which accords with the decisions of the European Court of Justice. That European Court of Justice these days is called the Court of Justice of the European Union. Anyway, but what if the two have a head-on collision? Perhaps purposive interpretation, which just wouldn't operate. There was famously the Merchant Shipping Act of 1988, and that collided with European law. So there was the Factor Tame Limited case about the Spanish fishing vessel. Anyway, it went through, there were a number of cases straight on for years, but it did establish beyond doubt that, yes, that an act of parliament, if that clashes with EU law, is struck down. But why are we doing this now? The United Kingdom is no longer in the EU. But it's true that the United Kingdom is abiding by European commercial regulations for the foreseeable future, supposedly just till December 2020. What will be the situation beyond that? We're not sure yet. So part of this Factor Tame litigation said the issue to begin with was providing interim relief because the European Court of Justice had to hear the case, and suspending the operation of the Merchant Shipping Act. So the House of Lords and the Court of Appeal, they refused to give the Factor Tame litigants what they wanted, and Lord Bridge, in the first case, because it went through a few cases, said the effect of interim relief would have been to have conferred upon them, that's Factor Tame, conferred upon them rights directly contrary to Parliament's sovereign will. I am clearly of the opinion that as a matter of English law, the court has no power to make an order which has these consequences, because it'd be, close of quotation, that would have been asking the court again to stand athwart Parliament's will, and it would be unseemly of a court to gainstand Parliament's sovereign will, and illegal, presumably. So what did the European Court of Justice decide in the end? Well, the ruling from the bench was that the House of Lords had to reverse its decision, because what does European law say on this point? European law is this: they must fully and uniformly be applied in member states in accordance with the principle of the presence of community law. Therefore, the United Kingdom was legally obliged to set aside an Act of Parliament. And so if a national law collides with European law, then that law is automatically inapplicable. That was a terminology used by the European Court of Justice, automatically inapplicable. So this is the second iteration of the factum case in the House of Lords, and this is what the House of Lords found. To insist that national courts must not be inhibited by the rules of national law from granting interim relief in appropriate cases is no more than a logical recognition of that supremacy. That's the end of quotation. So this UK Act of Parliament will face disapplication because it collided with European community law. Not the whole Act, but the sections of it which were in direct conflict with European community law. So was this intruding on parliamentary sovereignty? Possibly not. The House of Lords said this was a voluntary pooling of sovereignty. The United Kingdom was ceding some of its sovereignty to other European countries, and they in return were granting the UK some of their sovereignty. They were sharing it all. And this was voluntary. The situation only pertained because Parliament willed it to be so. And of course, that's not forever. As Brexit has proved, the United Kingdom has the right to withdraw, and as Parliament willed that this should be the case, it has been done. So how about the case law since then? So the supremacy of EU law has been reaffirmed time and again. There's Marshall and Southampton Health Authority 1993 to prove that. There's Ex Parte Equal Opportunities Commission 1995. Okay, so then last of all, we got what a certain judge, the Lord Justice Law, said about it. Yes, his surname really was Laws. He said we should recognise the hierarchy of Acts of Parliament, as it were ordinary statutes and constitutional statutes, which one's which, not entirely clear. There was Thoburn and Sunderland City Council case in 2002, the so-called metric martyr, when he said, he wanted to sell in pounds and ounces, and that clashed with European law that said you had to sell them in kilograms and so on, metric measures. He eventually won his case, actually. I'm not quite sure how that came about. Anyway, that is just a very brief introduction to parliamentary sovereignty. Toodaloo.